All right. Let me bring your bill up, Representative Romero. House Bill 83 provides relative to student discipline. Please proceed. And we have someone from the Attorney General's office as well. You have the cards for them? Please proceed.
Thank you, Mr. Chairman. Thank you, members. HB 83 will clarify existing law to make it even more clear that if a child is recommended for expulsion, then the child, his parents, or guardians has a right to an appeal. The decision to the school board, to appeal that decision to the school board, and after that to the courts if deemed necessary. It requires all school boards to comply with the existing law and review and revise their policies to account for virtual instruction environment. It ensures kids who were recommended for expulsion based on virtual instruction get hearings and can get lawyers to help them clear their record by granting reasonable attorney fees. Finally, it adds a new provision that allows reasonable attorney fees when a board acts vindictively or is grossly negligent in the charges it makes against a child. That's primarily what the bill does, and I guess if you have any questions, we can maybe let Ms. Liz speak. Ms. Morel?
So if you want to identify yourself for the record, and also if you want to make comments, you can proceed at this time.
Thank you, Mr. Chairman. I'm Liz Merle. I'm the Solicitor General, and I'm here on behalf of Attorney General Jeff Landry to support this bill and to answer any questions that you have about some of the legal aspects of the bill. We think that this is a very good bill because it addresses a problem that none of us really anticipated. And when schools closed back in March and everybody went to 100% virtual education, I don't think anybody contemplated that all the on-campus school policies would then apply to your home. There is a pre-existing statute that requires school boards to update their policies annually, and to do that through a statutorily created school discipline policy committee. Based on what we've been able to discern, few, if any, boards have actually done that since we've gone into COVID related virtual education situations. And in March, everybody went into months of extended 100% virtual, and now we're in situations where it's hybrid, but there's widespread use of computer technology where people are in school on computers. There's one child that we learned about that had been on Zoom school for 5 straight hours when he did something that caused him to be recommended for expulsion. Mauri's here, and he and his dad can tell you their story. Mr. Tim Brown is here, and his son also experienced an issue with a BB gun, and so, you know, these are things that I think caused us all to start thinking about the myriad of ways that you could inadvertently be triggering the existing kind of structure for expulsions, mandatory expulsions. And the reason that we really focused on the due process rights and the ability to get a hearing at the school board level and to get judicial review later when you've been recommended for expulsion. I mean, first of all, we think pre-existing law already grants those hearing rights. It says upon recommendation for expulsion. It does not say upon expulsion. But to clarify the law and make that clear, I think just resolves a problem that could be exposing a lot of students to the loss of their due process rights. But once you're recommended for expulsion, the families have there's not much they can do at that point, but especially if it is a gun, a weapon, or a drug-related offense. I mean, here, just by way of example, a BB gun in the bedroom triggered at least 3 that we know of cases where there were recommendations for expulsion. There's one child that I'm aware of in a different parish than these kids, where the kid was expelled, and he was referred to juvenile court on a Title 14 criminal violation for possession of a gun in school. He was at home in his bedroom with a BB gun. So then there's also the attached problems where they can put other conditions, like a probationary contract where you have to waive all of your due process rights. So Once the recommendation for expulsion is made, the parents don't really have a lot of ability then to negotiate anything. They have to pretty much do whatever the school says. And I think that's what we've seen in some of these other cases, in a variety of cases. We think the law allows for an appeal to the school board and then subsequent judicial review. That amendment, the language in this bill clarifies that, makes it express. It also provides an appeal process that applies now for the period from March 13th till the time that they comply with the disciplinary policy committee review. So it's not forever, but it provides a process right now where kids who've been disciplined with a recommendation for expulsion or suspension, that they can get in and get their cases reviewed because the boards haven't really revised them to adapt to virtual home situations. So we don't think that the law currently written applies to the home. And I don't think that anybody that saw this story in the news when it first came out or any of the related similar stories thought that it applied to your home. So all we're asking, I think, in this bill is for school boards to go back, look at, put these policy committees that are already in existing law together, revise your policies, and think about what the policies need to be when you are applying them to the House, because they shouldn't be the same, and they can't be the same constitutionally when you're in your bedroom or you're in your house. And I think that they need to give some thoughtful consideration to how those policies should be written, and we're not telling them how to write them or what to write.
All right, Senator Jackson for a question.
Thank you, Mr. Chairman. More for a statement, because I always try to keep my word back home. I had somewhat of a proposed amendment that I've talked about with the young gentleman sitting behind the representative and his father, but I understand that may impact the bill. I've talked to the author of the bill and Representative Garofalo, and I just want to put that on the record about offering something different on the floor to protect those children who are bullied from having to come to a school board meeting and testify against the accused. And so we're working on that, and I think that will clear up that. And I tried to get to a magic number. We're not going to get to it today, so I want to just publicly say for those back home watching this meeting that I will not be offering that amendment, but I will be working with the author from now to the floor to come up with something, if at all possible, that still protects his right and others, while, taking care of those issues that I heard from back home. I do want to commend the young gentleman in his advocacy, Senator Fields, and I always say this on the record, even when you were not, a member in the Senate anymore, that what you do at leadership is exemplified here, where a young person can come and advocate for themselves before those who are elected to represent him. And so I am not touching his bill without great clarification, because he's done what we encourage students to do every year, and that's come before us and advocate for themselves.
All right, thank you, Senator. Senator Talbot.
Thank you, Mr. Chairman. So, Mr. Muro, this is what I'm trying to get my head around, and I think you may have answered it, but you could clarify for us. So this bill only deals, or does this bill deal with kids that are just suspended where they get the hearing?
No, as a general rule, it does not deal with kids who were only suspended at all. There is a provision with regard to just the kids that were suspended or recommended for expulsion based on virtual school violations. And because we don't think the policies have been updated to deal with homeschooling, we think that they haven't complied with the statute that requires the update to the policies and notice to the parents. So there is one application to suspended students, but it's only those kids who were disciplined based on at-home virtual problems since March 13th up until the time they comply with the existing law that says to update your policies. And that statute that says go through an annual policy review, that statute requires that they have a meeting the first week of school and tell students and give parents the policies, and that way everybody knows what the rules are. So part of the problem here is that in every one of these situations that we've encountered, the parents have said, wait, my kid was in his bedroom You know,
Right,
I mean,
no,
I was
I-
at home. I mean, they were like, there needs to be more. We've got to examine what the right rules should be, and we aren't here. I don't think any of us are here suggesting that schools can't have policies surrounding what appears on the screen, how students behave on the screen, and all of those things. But it just needs to be something that has gone through the policy review process, and you've already built that into the law. We just want the boards to go back and go through that process and give notice to parents so that everybody understands what the rules are before they find their child's being recommended for expulsion.
All right,
Or
so
suspended, but.
And Senator Talbot, if I might add,
Yeah.
we were very careful to make sure that both sides of this were gonna gain some knowledge. They were gonna get some rules, whether it's the school side or whether it's the child or the parents that are struggling to try to learn at home. We were thrust into this. I mean, this came about very quickly, and the school systems and they needed to move fast, and those things maybe didn't happen quick enough. And if we just give everybody the rules, they can learn to follow them. Correct?
Senator Talbot, the way the law is structured now, when they are recommended for suspension, after they have a hearing with the superintendent or the superintendent's designee, it's over. They don't have a right to
right,
it.
they don't have a right to a
We're
school
not
board.
touching that.
Correct.
Right. But what you're saying is if that student was suspended during the virtual learning time between March 13th and now, whenever it ends, if they did get suspended under that, they would get a hearing in front of the school
They
board.
would get a hearing to review because we don't think that the boards have actually updated their policies to account for this situation. And there is, if the board's not going to review those actions, the parents are basically stuck. I mean, I don't think that it's fair. We don't think that it's fair for the school boards to not have complied with the update of their policies to account for this situation, and then the children have to suffer the consequences of that. So it's just wipe the board clean, have a hearing, do something, fix it. I mean, maybe they did something wrong that violates something that was clear in the policy. I don't know what the outcome of those hearings will be, but we think that for this virtual period, when they thrust all these families into that situation, that they should get a hearing. I mean, these are the people who got elected to represent them.
So on page 3, I guess lines 2 through 8 is where you're gonna make the school boards clearly define the rules of conduct and expectations for students engaged in virtual instruction.
Right.
Right, I love that part. If that goes into law, is there any reason to mandate the child who's suspended going in front of a school board hearing if they're gonna? I mean, would you have the? It would seem to me that you would let the students have the school board hearing if they were suspended during this virtual time when these things weren't mandated. But once you mandate that instruction, shouldn't that bounce back to where they?
It does revert back. So this section 2 is not going to be codified. It doesn't become part of the revised statutes. It's a law. That's the way they do it. Like it's only kind of a temporary. It may, and even if they do codify it, it's got a bookended period of time during which it is effective. So it's not changing existing law. Once they comply with the Policy Review Committee statute,
Then only expelled kids
into
would
the
get the
regular
hearing.
statute.
Right. Then, so once they comply with this, then it would go back to where only students that are expelled would get a hearing in front of the school board.
That's correct.
All right. Well, that didn't. Okay. Talk to me about the attorney fees and all that. So currently, if my child gets expelled from school, from a public school, and I want to take them to court, I cannot recover attorney fees. I'm not entitled to recovery of attorney fees. Is that correct?
You're not statutorily entitled to attorney's fees, and you may pay them because the law right now provides that the school board could actually obtain attorney's fees if a court found that you brought a frivolous claim, then you may pay their fees, but there is no flip protection to parents if the board brought a similarly
Like if the board was gross and
vindictive
negligent.
or grossly wrong claim or anything like that. I mean, so the provision that we put into the law is a very, very high standard. It's not just you get attorney's fees if you win. It's you get attorney's fees.
You have to
if
prove
a-
that they were grossly negligent and
Right.
that it was a
or
frivolous
vindictive
case or
or
bogus
false.
case or whatever.
Correct.
All right. I think that's it for now. Thanks.
All right, thank you, Senator. Senator Abraham.
Thank you, Mr. Chairman. Senator Talbot asked most of my questions because we've been talking about it, but I'm still a little, need some clarification. Under current law, forget about the virtual. If they're expelled, okay, they can appeal to the school board, right?
The way the statute reads, it says upon recommendation for expulsion, then you are entitled basically to your due process hearing with the superintendent or the superintendent's designee, and then you can ask for a hearing with the school board within 5 days, and then after that you can ask for judicial review. I think you have to do that within 10 days. That's the way the law reads now. Our interpretation of existing law is that those rights are attached, and you are entitled to those rights upon recommendation for expulsion. Not everybody agrees with us. We issued an opinion a couple weeks ago. The Attorney General put out a letter, sent it to all the school superintendents and the school boards, advising that this was how we interpreted the law, and that we believe that when the statute grants these rights and they are triggered by the recommendation for expulsion, that the boards can't back convert, the superintendent can't take those rights away by converting the time basically to fall within the scope of a suspension. They were triggered by the recommendation. And I think that's good, because if you read the whole span of these statutes, we have created a system that it puts in place a whole bunch of mandatory recommendations for expulsion. And then some of them even require mandatory periods of being out of school or in alternative school. They may require a referral to the district attorney. It's a big deal. And I think that even if they get converted back to a suspension or a period that amounts to a suspension, which is less than 10 days, they still could have all these other conditions. They could have a probation contract. They could have, and the probation contract I saw required them to waive their due process rights for any future violation, and then that person could be automatically expelled. So there are consequences even if they cut it back.
No, and I understand, and I'm okay with that.
Yeah.
But my question is, under that scenario, forget about the virtual, can they recover attorney fees when they go to a judicial review?
Under the statute, they cannot.
Okay, so my question is, why are we putting it in this one for virtual? That's the only issue that I have here, that we're doing something different that's in current law, and we're putting it in a new law that gives them the right to have attorney fees because it's virtual. That's the only thing.
Well, I want to be clear. It's in both. We are adding it to the existing permanent law, but at a high standard that requires proof of, prospectively, that requires proof of vindictive behavior. And actually, I think we were making it retroactive to December, but that was just a provision that was going to change existing law. The virtual provision does allow attorney's fees without proof of the higher standard, because we don't think any of the boards have actually updated their policies in compliance with the disciplinary policy committee.
Okay, I follow. And that's what after they do their rules, then you'll have a different. And
they will go. Everything will revert back, but you still have the high standard for fees. Under
this bill, expulsions will be able to recover attorney fees at a higher standard, whether it's expelled from virtual or the expelled outside of virtual.
It won't matter.
Okay, that's what okay.
It will just apply to
unclear that we were doing one class, giving one class a break and not the other class.
Yeah.
But okay, I'm clear now.
It applies to those people who have filed a claim. So when you're suspended, you don't have a right to judicial review.
Yeah.
You don't have a right to an appeal to the board even. So it as a practical matter, it applies to those people who have been recommended for suspension and then carry out the whole process all the way through court. And then they are ultimately successful. And then if they are successful, they would still have to prove that higher level of conduct in order to get attorney's fees.
Okay, I'm good with that. I think you explained it good. I just didn't want everybody coming after attorney fees. I didn't want everybody to be able to, on a suspension, they can, appeal, and we have too many appeals. But I think you've got it right.
And just to be clear, too, there's a damages provision, but that damages provision is intended, and I'm working with the School Board Association to clarify some of that language, but that's because in some of these cases, families are having to go through social work evaluations and other things like that. Those cost money. And so, we don't really know what all the situations may occur, but if you've put a child in alternative school and that child needs counseling, or if you've put a child if you've subjected them to a social work assessment and had to pay for that, I think that is appropriate for the court to be able to require, if you're successful and you showed that it was an unfounded charge at that level that's written into the law, then they should pick up the tab for that, not the families.
Yeah, okay, that's good, thank you.
All right, thank you, Senator. Senator Talbot.
Thank you. Thank you, Mr. Chairman. So, for the kids that are expelled or disciplined in the virtual time period, they don't have to meet the high standard?
No, because we think those policies should have been updated to account for the home schooling, and they weren't. So they should have their records cleared, frankly.
I agree with
and
that.
And the boards can, they can avoid the attorney's fees if they would just proactively look at that. We don't know what the scope of how many cases there might be right now. We've seen a handful. Enough to know that everybody should go back and look at their policies and update them.
All right. On page 3, line 9, it says any student who has been subjected to suspension or recommended for expulsion for behavior. That's the line that keeps giving me pause, that a kid could have a mouthful of food when he's supposed to answer a question and get suspended, and now he's going to go sue for attorney fees and have a hearing and all that? Shouldn't it say?
Question why they would suspend a child who's in virtuals at home and is sitting at his kitchen table and he's eating a sandwich, and now he's going to be suspended for eating in school.
That was kind of a tongue-in-cheek example. But let's just say he was suspended. So we're going to give.
They need to update their policies. If they didn't comply with the law, and it doesn't apply to the home, they're not in a position now to even be applying these policies to your house. And so that's the point of this. Nobody has shown us a policy that shows how any school board policy or that's approved policy would apply to your house.
I get that. This is what sticks in my craw, is that someone who could get suspended is now going to get this hearing and attorney fees and all these. He's subject to the same thing as someone who is expelled. I guess what it should say is any student who's been subjected to or recommended for expulsion that was knocked down to suspension maybe, but now we're throwing in everybody who was even suspended for that virtual time.
We're throwing everybody in that should have been. Everybody else would essentially have been covered by pre-existing policies.
Right.
So those are the people who were never covered by these policies but are being subjected to discipline that they did not get notice of and do not know about. And if it was your child, you would be saying, well, nobody told me he couldn't do that. That's the fundamental reaction that every one of these parents has had, is nobody told me. And so I think that, yes, it applies to suspension for a brief period of time, but it is a very brief period of time.
All right. Thank you.
All right. Thank you, Senator. Senator Jackson.
One last thing these masks, one last thing that you brought out that I wasn't aware of. Is this going to apply, and I'm in total agreement with this virtual, because I think parents had no notice of what was going on, what they could and couldn't do, and what schedule their children were going to be on, because it was very questionable as we ended the year before, whether your child could eat. So that's my issue. Is this going to apply to in-school suspension? And is this going to apply when your child is sent to alternative school in lieu of suspension?
Well, I think to the first question, does it apply to ordinary suspensions? No.
No, to in school. Okay, let me give you an example. If expulsion is recommended, and in lieu of expulsion, they do an in-school suspension. Some districts, if I remember, still have what they consider in-school suspensions, where you go to a separate classroom for a few days.
But these are, if they were at the outset, they were recommended for expulsion, then they get these appeal rights.
Right. But I'm asking, if you're recommended for expulsion at the offset, but somehow there's a resolution where you're in school suspended, you go to the separate classroom, will this apply?
Yes.
Okay. And let's say you're recommended for expulsion, but instead you're sent to the alternative school. Will that be considered a suspension for the purposes of this bill and the application of these rules?
The rights attached when upon recommendation for expulsion. So you will have the right to appeal it. And that doesn't mean you have to. You know, a parent can choose, can decide that they're okay with what the resolution is, and they're not going to take it any further. But the way the law is written now, it says, upon recommendation for expulsion, you are entitled to these hearings. And so it is, you know, the way due process works, the way that the cases say, they say that you can statutorily create rights. You can create due process rights by statute. So when you write a statute that says, upon recommendation for expulsion, a child is entitled or his parent is entitled to a hearing with the superintendent, an appeal to the school board, and judicial review, our view is you are vested with those rights no matter what they do on the back end. They can't take them from you.
And I understand historically, but right now as the law is written without this bill, if you're recommended for expulsion, but prior to the hearing, you are suspended, do you have a right to the hearing?
We believe that you do.
How has the application of it been?
I think, well,
I
at
think you're going
least
to hear
in
testimony in
yeah.
just a minute that says the other side of it.
We
The
know
other
there
side
are
is
some
that right
boards that
now in
don't
the
agree.
Whereas
application-
in other words, they were expelled, and then it was bumped to suspension,
Right.
and they did not get an appeal.
They were recommended for expulsion,
That's
but it was
correct.
bumped to suspension, and they didn't get an opportunity to appeal.
No,
Now, I
that's
want to
the problem.
separate my questions. All of my questions are not relevant to virtual.
Okay.
I agree with the bill totally on virtual. I think that the offset of what happened was because a student was in a virtual setting. And then I think there's a second student that I did not talk to. Was he or she also in a virtual setting?
Yes.
All 4 cases I know of were all in a virtual
Okay,
setting.
so the bill deals with virtual. I'm clear there. The other side of the bill, because I believe in protection of your home. I believe that we were very unclear. Because, see, I didn't understand. I thought this was all virtual. Now it's getting a little deeper. I believe in all of that. We get to this other side of the bill where it deals with if a student is in the classroom, right?
It's existing law that applies to any recommendation for expulsion, doesn't matter where
I
it
understand
occurred.
existing law, but this bill stretches out existing law.
No, it just explains what we already believe to be existing law.
It stresses out the application of existing law.
It makes clear, it makes it expressly
What the
clear.
process is.
Okay, because right now an application, and that's what I keep asking, because we are stretching out the application of existing law. Right now in school systems, if a child is in the classroom and he or she is are at the school, on the school grounds, they're not virtually learning. Okay, because I understood that we were trying to fix the issue with virtual. But if a child is a non-virtual student, they are in-school student. Right now, as it exists, when you're recommended for an expulsion as an in-school student, then before a hearing, you are suspended or sent to alternative school, or you have in-school suspension. You do not receive a hearing. That's the application of existing law. That's how it's being applied right now, right?
Not everywhere, no.
That's what I'm asking. And
I
that's
know
where I'm
there
not
are
getting clear.
some districts who interpret, they believe they have that flexibility in the law, and we do not, and the Attorney General's office believe that they do. And we wrote a letter to all the superintendents expressing our view of the law. And at least one board has said they think the Attorney General is wrong. So the bill is intended to clarify existing law because we know that there is some difference of opinion on that. But
So
we
the
think
bill
that
is
is
going a little
existing
bit
law.
further than what in the offset, and it's just where I'm looking. In the offset, it's going a little bit further than the virtual. It goes a lot further than the virtual situation.
I don't know that it goes any further. It just clarifies the existing law.
It clarifies the existing law for which you believe it should be interpreted, right?
That's
and I've
correct.
done that before, and I'm generally in favor of that. I get it, but I'm trying to understand for in-school suspensions. Will we go through these entire hearings if a student who's first recommended for expulsion is reduced to 2 days of in-school suspension, which means that student is still in school? Will we still go through the hearing process and the ability for that student to receive attorney's fees from the school system?
So yes, in the sense that we think they already can do that, but that is because when they recommend them for expulsion, there are other things that they may attach, because you have essentially given them when you recommend them for expulsion, obviously you have done the harshest thing possible. You have put them up at the height of the charge, the worst charge that you can assign to them, you have assigned to them. And so anything that happens after that, the parent is in a position of having to basically take it. So if they gave him a 2-day suspension and the parent was like, okay, okay, we're good,
Right.
then we're done. It's over.
No, I understand, but it gives
But
the
the
parent
law
the right to
now-
go further.
The law now says you can apply you can get these appeals.
I know what you and I may feel like the law does, but it seems like the school systems don't feel as though that's what the law done because they haven't put it in practice.
Well, I don't think it's fair to say they all haven't. I mean, I got an email back from one school board that said, "Thank you. Your correspondence was well received."
Out of how many school systems do we have right now? Because I know I have two in one parish in my district, in one of my parishes. How many school systems?
I don't know.
I don't know that
Like
answer.
68, you said, Beth? So 1 out of 68 have not been applying.
I mean, it's possible that only 1 out of 68 is applying it the
70,
way
so
that
it's 70.
without giving them an appeal.
So right now, from our limited knowledge, 69 school systems have implemented the law.
No.
I guess well, you said you
I
got
don't
an
have
email.
I do not have 69, a list of what all 69 school systems are doing. All I tell you is we interpreted the law as triggering these appeal rights because it says upon recommendation of expulsion. It doesn't say upon expulsion. It says upon recommendation for expulsion. I didn't write that law. The legislature wrote that law, and the legislature established those appeal rights upon recommendation for expulsion. So if you want to change the law and say that it only applies when they get expelled, that is your prerogative.
I will ask my question because I want to know what's in practice, and you guys are saying you don't know definitively, and I get
I'm
that.
saying I know
Yeah.
one that does it one way and one that does it the
Another
other.
way,
And
and we don't know what the other 68 are doing.
Not that
I think
know
it's
of.
clear that we need to clarify the law.
Right. Well, I'm asking a question that's not regarding the clarification of law. I'm asking a question regarding what the school systems are doing. But I think we have someone that's going to speak on behalf of the school systems that can tell us what they're doing today, right? Do we?
The School Board Association is
School
here.
Board
I'm not
Association
sure
probably
they've
can.
con-
I'm
they've-
just trying to get clarification because I understand and I fully support the portions that deal with virtual learning. 500%. I do not believe your home should be an extension of, at any time, of a school classroom to the degree of invading that person's right to privacy in their own home. Although I do have concerns because of a case that came out over the weekend where a child was found in virtual school in another state where the person was doing something very unacceptable to them, and that person was a parent. So I don't want that right to privacy to, you know what I mean, to extend to that home. And so I'm going to ask those questions off the record to make sure we don't get caught up in what we're creating that gives them a serious right to privacy where they can't come in and deal with illegal activity, right?
Right.
And so, but now it seems that we've stretched it to in school, and my concern becomes if that person is in school suspension or in alternative school, that we're granting them this right, which kind of gets into a gray area.
Well, I understand your concerns. The bill has always been written to address two different situations. One was to clarify existing law on appeals, and one was to deal with virtual.
Right. But I think the problem we're trying to fix is the problem that arose with virtual, right?
Both. No, both.
Both.
Because that one problem revealed the other problem. So the bill has always been intended to address the appeals process and to provide a mechanism to address the virtual situation. And just to update policies, nobody is telling them what to write. I mean, because of the situations you just identified, there are situations everybody recognizes that should be proper for discipline. So we're not here to say how to write the policy. We think that the policy review committee, the discipline policy review committee that's created by statute now, exists for that very purpose. It is supposed to meet annually and supposed to update policies and give them out to parents and kids. And that's to avoid this kind of problem where everybody's saying, wait, something new came up and nobody revised all their policies.
No, I get it. But even, and Mr. Chairman, I know I'm speaking a long time, but I want to really understand this with so many calls from home. Even in the situation of virtual, which I agree with, there tends to be no exception, and I'm speaking, we have young folks in the room very narrowly in my language, where we had a situation where illegal activity happened that harmed a child while they were on virtual learning in another state. If it happened like it did in that state with another child from the same school system being present, right? Does that mean that that child who would be suspended for the abuse of the younger child would have a right, well, recommended expulsion, later suspended, would have a right to all these appeals and attorney fees? Because I don't want an unintended consequence to happen. Okay, if two students are virtually learning in the same family, and the older student from that same school system did something to that younger student, under this bill, if expulsion was recommended, and then there was a suspension of that older student, with that older student who clearly was in violation of criminal statute, be allowed this hearing as well as attorney fees?
I think you would get but the hearing goes to the school board first. It can be stopped there immediately. You understand? I mean, once it's backed up by the school board, then that child takes that, or that the parents take that as that part of the responsibility of the child that really misbehaved.
Okay.
And the
And
hearing
you can't
process,
take it to the next level because you're not going to win there.
and the hearing
some people
process
do.
isn't built around, I mean, it's built around the level of discipline that triggers what type of process, right? So suspensions, you don't get a hearing past the superintendent or his designee. But expulsion recommendations open up a whole new situation for the student. So that process is not built around, I mean, there are some exit ramps for some of the mandatory recommendations that deal with drugs and guns and knives, but there are a whole variety of other situations that may result in a recommendation for expulsion.
Right.
And so other than those three topics I just mentioned, the law doesn't say, you have to do certain things in response. It just says, they can be recommended for expulsion, but you get these appeals. So the appeal process would work itself out. I mean, if that child was properly disciplined, then those reviews are not going to be very successful
So
for that family.
if the school board finds that that child was properly disciplined, then that person is not awarded attorney's fees.
No, absolutely not.
Now, with the creation of this process, can the parent then go, when the school board finds that, and I think the answer is yes, because they could have gone without this process, the parent can then file suit against the school board, but they could have done this without that process. They could have
That's
filed
right.
suit at any time. So
That's
that's
correct.
This process doesn't impact that. Okay.
Well,
I mean, if they brought a 1983 claim, like, they could still sue the school board. Like, no, there's
Regardless
not,
of what we put in law
regardless.
today.
Right.
Yeah.
And I think it's important too that we distinguish between the at-school environment and the at-home environment.
Right.
If this happens at school, it's going to be easy for that school to defend themselves and say that this was not in the policy.
And I
we
think
need them to
that's
set
my
it up for virtual.
concern. It seems like we're using the same format for appeal with no difference or no deference to the child being in school. It seems like the parent has the same rights, the same format of appeal, the same right to attorney fees, whether it happens virtually or in school, which is why my initial line of questions started with the two differences, that I think you do have a higher degree of privacy in your home.
Absolutely.
But it seems like that in the bill, we're weighing the appeals process is the same whether it's in home or at school, which means you're giving them the same degree of privacy regardless of where they are.
So first of all, the attorney's fees after this special, other than in that special COVID period when they update their policies, the attorney's fees only kick in unless it's very agreed. It can be proven that the school board behaved in a way that was grossly negligent or false charge or something. So it's a high standard even to get them at all. It's not just you get them. It's if you meet that high standard. So there's some deference to the board, and it's already built into that. But I don't think we want to have a situation that just says virtual school kids get this, regular school kids get this. I mean, this period of virtual, we created that only to accommodate the period where they had not updated their policies, and then everybody should have the same process. We don't need to treat them differently because one's in virtual and one's at school in terms of the rights that are afforded to them if they are recommended for expulsion.
The right to do more in his or her home.
The policy should reflect that.
Yeah, and that's my concern. concern is that because
yes.
we don't say the policy should reflect that, we're not giving them the ability in this bill to tier the policy.
Right.
Because bottom line is the appeal process is the same whether they're in school or whether they're at home.
But the
So-
discipline doesn't have to be the same, and that's why we built some
I'm
language
going to
into
finish
this.
kind of asking my question on this one. So we're not giving them, hear what I'm saying? I believe that there's a higher degree of privacy and that there is a different situation when you're sitting in your home than when you're sitting in school.
Right.
But it seems that the bill does not allow, Representative, for a distinction in discipline based on the home or the school. Because what happens is, it seems like it's the same appeals process, the same timing, the same everything. There's no special provisions to me in this bill for my higher degree of privacy in my home.
So,
And-
We're hopeful that that's what this will do. The policies so it's requiring the schools set policy, even though that requirement's already in place in statute.
Right.
But we need those policies to be set so that the child will know what to do at home and what to do at school.
Right, and I
mean,
agree
that's
with
that's
that.
the key to this bill. It's set the policy. They'll follow the rules. If they don't, then there's going to be a process.
I agree to that, but when we get into the appeals process, like I said, it's the same appeals process whether in home or in school. It's the same degree of what you afforded in the protection of law when you're at home or at school. And I think we all lose, just like the school free zone, I think we all lose some ability and some rights based on being in that public school building. This bill doesn't distinguish that in the appeals process.
no, but if you look at subsection K, where it defines virtual education, and it directs schools basically to define the rules of conduct and expectations of students in a virtual instruction and to take into account their constitutional rights. So I think that is intended to address your concern, and that is that when they write the policies, they should be taking that into account, and they should be recognizing that you have greater rights in your home.
Oh, I agree that when they write the policy,
Yes.
they will signify greater rights in the home. But the bill gives the same appeals process, the same rights for appeal, whether you're in your home or not. So when we get to the process of appealing the decision, even if you have greater rights in your home, it really doesn't matter because you're under the same appeals process as someone in school, right?
But I don't know if
that
we
is-
could give them
yeah.
more.
Yeah, I think we should give them more. I think that's what I'm saying.
I just don't think there's any more that we can give them. I mean, they already had the right, if they were recommended for expulsion, to go to school board review and to go to court. That's going to cover the whole gamut of their due process. I mean, that gets you into the pipeline to have the ultimate review by all the way through the court system. So they can raise these issues while they're there, but
Okay, so
there
let
is
me-
nothing more we can provide.
Let me try this and then I'll be through, Mr. Chairman, I promise. You're in school and there's a fight that's caught on camera and every kid's have it. Every child has it because it happened. We see it all over Facebook, or you've bullied a special needs child. Under this statute in school with all of those videos, the parent has the same right for appeal in the same process as the child that's sitting before us. That does give me a bit of pause when we start talking about this. And I think Garofalo and I are going to work on something because I think my major concern is putting that child who's already on video, putting that child who's already been bullied through the appeals process and coming before, I don't have any problem with that at home. I really don't. Now that I'm fully gauging what's happening. I do have a problem that someone that is caught on video doing something criminal in nature on the school's campus will have the same rights as a child sitting at home in his or her home have in a case that was presented to us, or the 3 or 4 cases that's been presented to us. That's probably where I'm having a little bit of angst with it, right? And so I'm not offering an amendment, like I said, but as I further discuss this bill, I do see a couple of problems with the in-school portion of it that basically divests the school system and that school of the rights they generally have when a student steps on their campus.
All right, that concluded your remarks, Senator.
And just for the record, because I'm not going to come back on the mic, I promise you that.
Take your
if
time.
whoever's representing the school boards or the school system or the school board association, when they come up, when you testify, please tell me in this committee what school systems are doing what. How many interpret the law in a way that doesn't allow for a hearing, and how many interpret it in a way that does allow for a hearing once it results in when it moves from expulsion to suspension.
All right, thank you, Senator Jackson. Members, we got several people who wish to be heard on the bill. But hold up, wait, Senator Mizell. Hold 1 second. Senator Mizell for a question.
I just, thank you, Mr. Chairman, and I'll be brief. I
your
think that, I'm not a lawyer. I understand the concern. I think that a lot of the concern I had was that there would be a policy that would define the rules of conduct for virtual learning, and therein is going to change a lot of the concerns on who's going to be able to appeal it and what the outcomes could be. I mean, so then there would be a leveling of the process before there was an appeal, where the virtual student wasn't going to be judged in the same way as the student who was in the classroom, all those things within the parent's control. Okay.
And I think that's very true. And I think, in respect to Senator Jackson, I think there will be a difference. I think once that policy set, if you, and I'm going to just bring up a scenario, if you bring a gun to school, good luck appealing it. But if you have an issue like Kamari, you'll have that option. Does that make sense?
Right. And there's always, in the example you gave of a brawl. So, I mean, there's always guilty and innocent trying to get the same level of justice. Well, God willing, justice is going to take care of weeding out the guilty and the innocent. And that's what we're at the mercy of in everything we do. But at least we're bringing the rules to a compatible level where we're respecting the home environment.
Exactly.
And allowing everybody to have a moment of honesty in the process. So, I appreciate the concerns, but I mean, that's what I see as the intent of the bill.
I agree with you.
Am I understanding your
Yes,
intent?
I agree with you.
Okay. Thank you, Mr. Chairman. I just wanted to better understand.
All right, thank you, Madam Pro Tem. All right, members, the board is clear. Thank you all very much. Now we're going to hear from the two individuals who've been most affected. First, Kamari Harrison and his father, Naran Harrison, as well. If the two of you can come forward after we sanitize the microphones. And let me just say, Kamari, I want to apologize to you going in. You were here on Thursday, Wednesday, and we didn't have a hearing on Thursday, and you were here prepared to testify before the committee. So I would like to apologize to you, and I like that mask you're wearing. LSU, that's in my district, so I really appreciate you coming here supporting an institution of higher learning in my district. With that said, members of the committee, we give our attention to the two people who are most affected by this legislation. And y'all can, Mr. Harrison, you can start, or your son, however you wish to proceed.
Thank you, Mr. Chairman, members of the board, for having me and my son, Kamari, come back up to the state capitol. I'm sorry. Thank you, Mr. Chairman, for having us. My name is Naran Harrison. I'm the father of Kamari Harrison. We're here on behalf of my son being recommended for expulsion for having a Daisy BB gun toy in his room and it being seen on the camera during his virtual learning time. I was called by my fiance, that my son was being disciplined for violating school policies. And I headed home. I was in Algiers taking care of my grandfather. I'm from Algiers in New Orleans. I was taking care of my grandfather, who I take care of. He has dementia. I left there, I headed home immediately because I knew the significance of the matter, and I knew the significance of him having what they thought was a real gun, at the house. So I got there to deal with the situation. I'm the head of the house. I spoke with Kamari when I first got to the house. I was disappointed in him because I had received news that he was disobeying, school laws during his learning session. And he was informing me that he did nothing wrong, and he was just taking his test, and his brother came in the room and knocked the gun over, and he picked it up and moved it, and his screen, he seen his teacher yelling for his attention, and directly after that, his screen cut off, and, and I'm listening to him But in my mind, you know, and I'm still angry at the time. I'm getting even more disappointed because I'm feeling like he's lying to me when I teach him accountability and I teach him, you know, the difference between right and wrong, you know. And Charlotte, you know, after speaking with him, I, you know, let him hold that thought, you know, I'll get back with him. I spoke with the teacher on the phone. My fiance handed me the phone to speak with the teacher, you know. And I asked the teacher, Miss Williams, what was going on, what the problem was, you know, which I pretty much thought I had already known what it was. He was playing with his toy gun while he's supposed to be learning or showing it off to his friends like any other child would be doing during this time, you know, children that's not taught right from wrong in their house and don't get disciplined for things of that nature, you know. But Ms. Williams, you know, to my surprise, she told me the same thing that Kamari told me, you know, that the Daisy BB gun was just seen for a short second and Kamari was back to taking his test. He didn't see her trying to get his attention because his computer was on mute due to the fact that he was taking a test. And I didn't get to have too many more words with Ms. Williams after her confirming the story that Kamari told me, because I directly after that talked to the behavior interventionist who told me the same thing in so many words, but also added that he would be being recommended for expulsion. At that point, I spoke with the principal who got the phone from her right after that, you know, and doubled down on that and let me know, inform me that they was treating Kamari's situation as if he had brought a gun to school. At that point, I disagreed with the principal. I told her it's not the same. I feel like it's not the same thing, you know. And the conversation ended at that point. I didn't want to be going back and forth with the principal of the school in front of my son, you know, even though I hadn't let him know that he didn't do anything wrong yet or nothing, you know. But I disagreed with her, and I had to apologize to my son, you know, because I was angry. I had to apologize to him, and I had to apologize to him on behalf of myself and the school, you know. So from there, I talked to the principal again a few days later. I spoke with her that morning, me and my fiance, and we had to meet with her immediately that evening for further instructions, you know. This was a few days after, this was the 16th of September. And upon meeting with her at the school, she was telling me that they're still standing on him being recommended for expulsion, you know, and I'm subject to a hearing by the school board that I have to agree to meeting with the school board for them to make a decision on Kamari's case. And I was in agreement with that. I was ready to speak with the school board because I felt I had issues with their decision, and me and the principal, we couldn't come to an agreement on this issue. She felt like it was the same as him bringing it to school. I felt like it's not the same thing, you know. I didn't know the technicalities and the policies and procedures of him, you know, of this case and whatnot. But, you know, to find out there was none because she never presented me any, you know. She presented me with the only the grounds of her standing on, it's the same thing as him bringing a gun to school. You know, they're treating it, my home is an extension of the school, to quote her correctly, you know. And when this initially happened, to go back a little bit, I didn't know nothing about any rules or policies. I just felt like my home was like totally invaded. Once they told me that he wasn't playing with the toy gun and he was taking his test and doing everything he was supposed to be doing, now I'm like, so what y'all looking for? Like, what's the problem then? I feel like y'all just looking for something at this point, you know? And at that point, you know, in the office with her, I was short of words after I seen we wasn't going to agree on this, and they were standing on expelling my son or recommending him for expulsion, you know. And at that point, I told her, you know, well, I'll see you at the hearing, and I'll bring the BB gun there, and I'll bring 6 on Your Side Channel News, you know, with me, so my words will mean a little more. And they wouldn't just be, you know, I wouldn't just look like an angry black father coming in here, you know. So I had the Zoom conference meeting with the teacher, Miss Williams, the behavior interventionist, Miss White, the principal, the school board hearing officer, and an unexpected guest, Miss Chelsea. I call Miss Chelsea, you know. I felt like I needed representation because my conferences, my meetings with the principal and school staff wasn't going anywhere, you know. So I felt like if I brought me an attorney in here to speak for us, we might get some, you know, a little leeway in the matter, you know, being that I'm gonna have to pay for representation, I'm gonna have, you know, so I should get some good results out of this in that nature at least, you know, because they was firm on, you know, my son disobeyed school policies by bringing as they would say, a weapon prohibited by law on school campus, you know, and the hearing that we had with the school board, I felt like, you know, I could have just been in there alone and not even had, you know, paid my fees and stuff from Miss Chelsea from the results of how the hearing went, you know, and I just thank God that I had the wherewithal and the common sense, you know, to know that something wasn't right, and that I stood on my son's side, you know, at the perfect time, because, you know, this, as I'm learning now, I feel like I've been to school all over again the past 2 weeks with this case, you know. This bipartisan bill that's being passed is tremendous, it's big, you know, and not only is it big for my household and getting my son's name and record cleared, it's big for the state of Louisiana, it's big for all parties involved, it's big for Mr. Tim and his son Tommy, is big for everybody, you know. So I just hope that the bill get passed and no other child or family have to deal with what we've been dealing with, you know.
All right. We want to thank you very much for your testimony. You can remain seated. If you would like, I have a card from your son, Kamari. If you would like for him to testify, he's free to do so at this time. But before you do, I don't want to turn nothing off, but can we fold that laptop so the members can see his face appropriately? If you want him to testify, he's free to do so at this time, sir.
Okay, so I'm Kamari Harrison. I'm 9 years old. I want to play basketball when I grow up. My favorite player is LeBron James. And I thank y'all. I thank you for helping kids my age and kids like me that get in this problem.
Well, thank you very much, Kamari, for being here. All of us on this committee certainly appreciate young students like you who are serious about their education. Questions from members of the committee? Senator Mills.
Thank you, Mr. Chairman, and Mr. Harrison and Kamari. 2020 is a year we'll never forget.
I agree.
My hope is that, you know, you and your son continue to do the right thing and just forgive the system that is learning as it goes as well, because at the end of the day, education is so important that, you know, we can't take anger out of this. You need to get it fixed, and you need to have some people apologize to you, I think. But keep going. You're doing the right thing. I appreciate it.
Thank you for that, Senator Mills.
Thank you, Senator Mills. Any other members of the committee? Senator Mizell.
Just really quick, Mr. Chairman, I had the opportunity to meet you last week, and you're an impressive fella. And I may not agree that LeBron, you know, I've got other favorites, but I appreciate that you know who your favorite is, and you're paying attention, and you're engaged, and you're willing to put yourself out. This isn't a comfortable place for you to be. I'm sure you'd rather be doing something else. But I wanted to tell you, I have ice cream in my office. If you want to go by and get some, okay? Ice cream. Yeah. Thank you, Mr. Chairman.
Thank you, Madam Pro Tem. And Kamara, there are no other questions. Mr. Harrison, let me just say that, again, I want to apologize for last week, and we appreciate you being here this week. And the House went in, the House of Representatives, they went in at 2 o'clock, so I wanted to get all the House members out so that they could go and be a part of their deliberation on the floor of the House. And I appreciate you waiting. Thank you all very much. We have one other person who do not wish to speak, but would like to speak. Tim Brown. Tim Brown?
Thank you. Thank you.
Thank you very much, Mr. Harrison.
Wait, sir. Wait.
Mr. Brown, representing self. We appreciate you being here, sir.
Thank you. My name is Timothy Brown. I have an 11-year-old son, Tommy. He's in 6th grade, attends Grand Isle School. Very similar thing happened to my son. He was recommended for expulsion he practically showed his peers he owned a BB gun. Held it by the barrel dangling, Daisy Red Ryder. I was called down to school, told how great my son was. He's an honor student, never been in trouble in his life. Then she slid a piece of paper across the table and she had recommended him for expulsion. And you can imagine surprise, anger, disbelief I had at that. Had to attend a hearing with a hearing officer. Again, told what a great child I had, not a discipline problem, does everything he's supposed to do. And we'll call you later this afternoon. Later that afternoon, I'll send an email. Well, he's going to be expelled for 3 days and put on probation, which may require a social assessment. It states on there, I'm giving up, he would be giving up his rights for appeal. On this brought up absence, tardiness. It would go back to expulsion, the way I read this piece of paper. Sent an email to the school board wanting to appeal his case. I was told that he couldn't do that. And we weren't told what was required of us before virtual training started. I don't want my son in virtual school. I want him in school, and I have from the beginning. But we were provided no guidance. I definitely did not know that they considered my son's bedroom part of the Jefferson Parish school system. Because I have a major problem with that by itself. But this thing's been wrong from the get-go. And if somebody would have injected a little leadership or common sense at the beginning, I wouldn't be sitting here today. And I appreciate y'all considering this bill to help my son, Mauri, and any other children we don't even know about or, from this happening. And give them an avenue to defend themselves and get this off their record. Because right now my son's record said he possessed weapons, plural, not federally regulated, I believe it said. I don't want that in my son's file in the future.
Well, Mr. Brown, I can just say I want to apologize to you and Mr. Harrison, and hopefully, by the end of this session, this legislature will be able to give you some type of remedy. And I apologize.
Thank you. Thank all y'all for
All right, there are no questions. Thank you very much, sir. We do have 2 cards in support, but do not wish to speak. Christy Cross with the LFF, I think, Louisiana Family Forum. And we have Kamara's attorney, Chelsea, I can't pronounce your last name. Chris All right. Thank you very much for being here. Now let's take the opposition members. We have 15 minutes. So we do have opposition. We first have Wes Watts with the Louisiana Association of School Superintendents. If you come forward in opposition, do wish to speak. And we have Jennifer Ansardi with the Jefferson Parish School System in opposition and would like to speak. And she may be in the next room, so if you come forward, okay. If the 2 of you come forward, and I don't want to rush you, but we do have some time restraints. Please make your presentation.
Thank you, Mr. Chairman, committee members. Wes Watts, I am representing the Louisiana Association of School Superintendents. Tough bill to oppose. More than oppose, there are just a couple of questions or concerns that we have with it. And just understand that COVID-19 has put our school systems in a tailspin. And when March 13th hit, we started doing everything possible just to take care of our kids, feeding them, making sure we interact with them, reaching out to them, doing everything we possibly could to try and take care of our kids. And saying that policies probably should have been written back in March, I think was impossible. Our job was to take care of our kids and our families. We did everything possible to do that. My concern and our concern with this, more importantly, is the appealing of suspensions. Just the feeling of our school board meetings with appeal after appeal after appeal when it's about a suspension. I asked that question in House Ed. We were told it wasn't going to be suspensions, but only recommended expulsions that were reduced to a suspension. And so that's my concern. A 2-day suspension being appealed, I mean, those happen quite commonly. I would just speak for my school system. We did review our policies. We did communicate with our parents. I know y'all were asking a while ago. You've heard concerns from 1 or 2 out of the 69 school districts in the state. I would say most of them did, probably, but I can't answer for them. But that being said, it's tough if we put all those suspensions, and those can all be appealed. And just the lining up at the door at our school board meetings and then in the district courts. So that would be more of, instead of an opposition, maybe some amendments to that to make some change there.
All right, thank you very much. And if you remain at the table, we'll take Ms. Ansari.
Thank you, Mr. Chairman and members of the committee. I'm Jennifer Ansardi, the legislative liaison for the Jefferson Parish School System. With me also is the outside counsel for the school system, and I believe he's also going to speak in tandem. But in my role, I'd like to talk to you about the merits of the bill. And first, to put it on the record, we do have some concerns with the bill, but our primary goal in these unprecedented times that we're all facing is to ensure that the children have a safe environment and to educate them, safe and secure. And we do have policies and procedures in place that were revised during the COVID-19 to accommodate and tweak some things to be able to accommodate children, education during these times. We make those available via, we have it on the website, we have a virtual learning policies, we have, and presented to parents during the parent-teacher conferences and different modes. So on the bill, some of the issues that we have, that it applies both to virtual and non-virtual classrooms. There's references in the bill that suspended students who were recommended for expulsion, and in some areas and in other areas it's to all suspended, which was covered. It creates, for the students, it creates a new cause of action, which will authorize attorneys' fees and damages. In some areas, you have to meet the high standard. In other areas in the bill, it doesn't have that. There's also some conflicts about the deadlines for requesting and board reviews. Some days it's 5 with a 10-day judicial review versus 30 days, which is confusing. Authorizes damages and attorney's fees. I said that. It's retroactive. And another important feature, because we try, in our discipline policies, we want to apply them uniformly and consistently so that everyone's treated equitably. In this bill, it creates 3 different classes of, I guess, violations with 3, and allowing those who were recommended or alleged violators different due process rights. So that's confusing too. They're not treated equitably. And all we ask is, if you decide to clarify the law and do these types of things, please don't penalize those that were operating with boards and policies and procedures in place and in compliance with state statute on some of these issues. We're not trying to hurt any student. We're just trying to keep everyone safe and uniform. And if you have any questions, I also have the attorney with me.
All right,
who
thank you very much, Senator Talbot.
Thank you, Mr. Chairman. Question for the gentleman. So you're a superintendent for
West Baton Rouge.
West Baton Rouge. All right.
Yes, sir.
How long would it take y'all, if this bill passes, which is looking like it's going to put in these policies? Like, is it going to take y'all 3 months, 6 months, 1 month?
You could probably possibly do that in a month, depending on the times of your school board meetings.
Okay. How many suspensions have y'all had during the pandemic from March 13th till now, if you had to guess? Is it like 1,000, 10? I mean, is it?
We've had very few. In terms of, you're talking about virtually, obviously?
Yeah.
Yeah, very, very, very few. I mean, we tried to we use the same policy. I'll be honest, our school district, we use the same policies for our own campus as virtual, but we did instruct our leaders to use some good common
Right,
sense. That
right.
home is more private.
Right, and look, I'm for the bill, but I don't want to overload the system anyway. So if you're only talking about the period between March 13th and I guess whenever this pandemic ends, which who knows when it will, and if there's very few suspensions, how will that overload the system?
My understanding is the bill says that any suspensions even on campus.
No, it's only, Mr. Chairman, unless I'm wrong, it's
Sure.
only during the virtual, it's only students that are learning virtually during the pandemic, correct?
The bill, as it's stated now, is during the pandemic.
Just during the
period.
pandemic.
It's just during the pandemic.
And I can only
then,
speak for my school system though, so there may be others that have.
no, I got you. And then once these policies are written, that goes away. So you can't, like, let's say the policies are written, and God forbid we're still doing virtual schooling in February. Those kids can't get that hearing now. So that's, it's going to end when those policies when y'all write those policies.
So
the window
equivalent
will
of a
shut.
suspension
Correct.
will end when?
When the policies, when the policies are written.
So when we rewrite our
Policies.
say our policies, when we go to rewrite them, we keep them as they are.
Right. Let's say you finish them December 31st. That way I understand it is moving forward, then they're not going to have this right to appeal suspensions to the school board.
Gotcha.
And then and all that. It's
So it's going to be retroactive.
You're going to go back
to March.
to March 13th, but it ends the day y'all get these policies in place. Mr. Chairman, that's the way I read it, unless I'm reading it the wrong way.
So can I ask a question about that? My
Yeah.
concern with the March 13th retroactiveness. We were given a stay-at-home order on March 13th. We just assumed that we were going to be out for a month and then we'd be back in school. And then there was another stay-at-home order. I think to expect school systems to write policy at that time.
I agree.
Would have been tough.
And on the same hand, that's why this gentleman Mauri should never be here. This thing should have never come to this thing. The thing in Grand Isle. I mean, I have a lot of guns in my house too.
Me too.
And it should have never come to this, but it is, and here we are. And just to let the committee know what I would like to do when the time is proper is to do an amendment. One, take out suspensions and have it just either expulsions or expulsions that were reduced to a suspension. I know that sounds a little confusing. And then it does bother me that the way the bill sits right now, if I had a one-day suspension during the pandemic, I can go and collect attorney's fees. And there's no bar to look at to say, as in once the policy gets written, you have to prove gross negligent, so on and so on. There's nothing for that now. I'd like to do two amendments. One, to say that, that applies to the pandemic period, and two, to take out the part about suspensions. But, the committee can decide whether they want to vote for it or not. But that's, I think, we're kind of splitting the baby, so to speak.
And for us, attorney's fees are one thing, and understanding that if a student they have a right, families have a right to appeal and to make sure things were done appropriately, and if they were not treated appropriately, right?
Right.
The ability to financially get counsel should not be a factor in that. So if we pay attorney's fees when we were wrong, that's one thing, but the damages were another thing.
Right. I mean,
that would open the door, we think, to be
right.
something bigger.
I mean, there needs to be common sense on both sides.
Absolutely.
I mean, if again, that's all my comment. Thank you, Mr. Chairman, and we'll have those amendments ready.
All right, good enough. Thank you very much. And Mauri, knowing this body like I do, that they'll probably make your bill even a better bill. So thank you all. There are no. Senator Jackson for a question. Members, we do go in at 3, and I apologize. Y'all understand the schedule better than anybody.
I'm gonna be real quick, and I'm with Talbot. I'm with Talbot today. Can you believe it, Mr. Chairman, on his last question?
I do believe that.
This is somewhat strange that this even came before us. How did your school district get to restricting what was in people's homes? How did anyone think that was a plausible restriction?
So for us, we didn't. I can only speak for my school district on that.
Okay.
I was just in opposition to some tenets of the bill for the long-term effects of school districts.
Okay, but you're not at all asserting that child shouldn't have had his own property in his room. Whose school district is this?
I don't know all the ins and outs of the case, Senator Jackson, but I would say home is private.
All right.
I represent the Jefferson Parish School System, and I'd like to bring, if, I think he filled out a card.
He has a card, and I'm going to call him next.
Yes, but-
Good,
So,
Mr. Chairman, it just still baffles me how we hear, but
Well, we're not trying to legislate what people do with their homes, but at some point, we have to also, whatever is not acceptable in a classroom, on the school bus, at a school dance, in a virtual, is not acceptable also in a virtual classroom. That's our position, but
but you understand that's your position, and let's bring Mr. Frederick Price up with the Jefferson Parish school system. Yeah, but you cannot take the position that the same rules should apply at a person's in a person's home that would happen on the school property. I mean, you got 4 or 5 students who may be attending school, and you got 4 or 5 devices going on. It seems like the more appropriate thing is for Bessie or somebody to have some policy where you have a dark or a blue or whatever, so you can't see what's happening behind you. But we certainly shouldn't be penalizing students like Kamari. But look, I understand your position. Thank you very much for your testimony.
thank you.
All right. Yes, sir.
Thank you, Senator Fields. Fred Price, senior partner, Brazil, Saxon, and Wilson. We represent the Jefferson Parish School System. And first thing I want to do is thank all the people in the Senate and the House. I haven't had a chance to do this, and the governor for signing tort reform. I'm also, one of my other jobs after I was chairman of LABI, I'm chairman of the LABI Civil Justice Tort Reform. So, and the reason I mention that is because provisions of this bill are absolutely in opposite to what we've just done at the legislature. And 2 parts, I know you have to break it 3. So the 2 parts are, number 1, attorney's fees and costs. It does not require the higher standard as has been brought out for some period of time through the pandemic. And second, it's retroactive. This is a plaintiff's attorney giveaway bill. Those provisions are. And we've got a lawsuit filed against us, the Jefferson Parish School Board, right now. There are 8 counts in there. So to say that this bill is needed for a lawsuit is ridiculous. There are 8 counts, 8 separate laws cited in that bill. Additionally, it is against 4 individuals, including the systems. So it's against our superintendent, our principal, our chief legal officer, and our head of operations. All 4 of those. Passing this bill with those attorneys' fees and costs, as well as no higher standard, puts them at risk too. That's wrong. That's just plain wrong for something that was done retroactively. That's just plain wrong. Let me say a couple of things because there have been all kind of commentators who have commented about this. I want to make a couple of very serious comments about what this is not about. What is this not about? Number 1, and I know this is the elephant in the room, some of these are. Number 1, this is not about race. It is not. Our superintendent is African American. He is Cade Brumley's second in command and was before Cade moved up. We got the 2 best superintendents in the world with Cade and Dr. James Gray. He's great. Second, the principal is African American. The teacher is African American. So it is not about race. Second, it's not about the Second Amendment. It's not about the Second Amendment. This is a toy gun, or it proved to be, and it's not regulated. It looks like it had a facsimile, which is against our rules, to being a gun, but that's what the teacher recognized when she saw it. I'm a teacher at UNO. I can tell you if I saw it, I'd know what it is because I carried an M16 when I was in the military, but she did not know. She's not trained to know those things. I can't comment about all the facts, but I can tell you that was the situation. Third, this is not about, this has a lot to do, but not a lot to do with privacy. Clearly, none of us want people in our homes, but as the AG's attorney said, we need some very specific guidelines. Right now, the home that is considered on camera as part of the school system. And so we tell our teachers to watch what goes on. I can tell you, Jefferson, we asked Jefferson, the Jefferson school system, what sort of situations they've had so far from March until now. So they've had students and relatives exposing themselves to the virtual classroom. They've had students capturing the screen to display pornographic materials. They've had students sexually harassing our teachers. That we have got to deal with. And we're not against having very specific rules and regulations. We want that. But what we don't want is to be held retroactively for individuals who work for the school system and the school system retroactively held liable for attorney's fees and costs with no higher standard. That's our problem with this bill.
All right. Thank you very
you.
much, Mr. Price.
sir.
Senator Talbot. Senator Talbot.
Yeah. Look, I guess my first comment, I didn't even know race was an issue until now. Has it been one?
There are some Senator, thank you for asking. There are some
I've never heard
commentators
it, read
who've
it.
written articles around the country that say it is. It is not. Not to us.
I've never heard
Our
it here.
school board, as you probably know, is the most diverse school board probably in the state.
So-
We have
sir,
African Americans,
I can-
females,
I'm sorry.
and teachers.
I can assure you race is not an issue.
Right,
in this
I
bill.
assure you, I don't think it is. But again, there is, and look, I'm expended more blood on tort reform than most, but I do feel comfortable with the language in here. I mean, grossly negligent manner, deliberate disregard for the consequences of the actions of the student, willful, malicious indifference, intent to deprive the student, his parent, guardian, tutor, due process, initiate a charge that is knowingly false. I mean, I think with my amendment, if it passes, that'll go into the virtual kids as well. And, I mean, do you think that standard is high enough? I mean, I know there is no standard right now for the ones in virtual, but if the amendment passes, it will be.
I think the standard is high enough if it also applies to, if this bill is passed retroactively, if it applies to the retroactivity.
Yeah, it would. Yeah, it will. It will. Okay. And look, I know, y'all kind of made your own bet on this one because it was kind of like, you say things like, we have to deal with all these new policies when then they should have written them. And there's got to be some give and take here, These parents are dealing with this stuff new for the first time as well. And a lot of them are homes where both the parents work. My wife works. My kids are older, thank God. But if my kid was 11 or 9 and maybe I had a sitter with them or so, it's just a hard it's hard to control that environment. So there needs to be a little give. This thing should have never made it to this point. The Grand Isle thing should have never gotten to this point. So here we are.
I can tell you, you're absolutely right about the fact this is a very difficult issue. I've probably done 25 webinars in the last 6 months, and you can't imagine what people do.
I know, but now
we need some guidance and guidelines. That's very true. It's a very good idea to send this back to Bessie or whoever it is that you want to make these decisions and get some written guidance for us on exactly what you want us to do. We're happy. The reason I think a lot of the school boards, I can't speak for all of them, didn't have anything is what the representative for the superintendent said. I mean, we have been running around like crazy just trying to take care of the kids.
I get it.
It has been, and you can imagine, you all had this in your own businesses. This has really been a tough
If you
time.
want guidance on what you want us to do or if you're looking for guidance from us, clear his record and clear Mr. Brown's son's record and let him move on.
That's a good point. Let me say something about that because there have been some unfortunate rumors. Number one, this is neither of these situations have ever been referred to the district attorney, nor has there been any intent to do that. Nobody has ever said we're going to do that, and we're not going to do that. That's the first thing. And the second thing is talking about the record. This has absolutely no impact on these kids, these students, into the future in terms of their being able to get into any particular program, any extracurricular program, or anything else. If you want us to hear it through our board processes, we can do that. The reading internally at the school board was that was not supposed to be done if an expulsion was reduced to a suspension, which is what happened here. And that was our reading at the time.
I know we're getting pressed for time, Mr. Chairman, but I mean,
understand.
it does have an impact on Mr. Brown's son. I mean, this letter, y'all want him to sign about probation for 180 days and all that stuff. I mean, that could have an impact on him.
Something to be considered by the board.
You want my guidance? Wipe the slate clean for both of these kids. We all made mistakes during this pandemic and move on. Thank you, Mr. Chairman.
Thank you.
Thank you very much, Senator Talbot. Senator Mizell.
Thank you, Mr. Chairman. I was going to just very briefly add that it has had an incredible impact. This is nowhere for a 9-year-old to have to complete his case. How incredible is that we've reached the point where a child has to come up here and say, please do something. This is just wrong. And the idea that, well, it may not affect his lifetime, but on your records, but I guarantee you he's affected by this for his lifetime. So I think it's easy to sit back in our roles and not be that 9-year-old. But you all have an incredible amount of responsibility on what you're doing to kids who are dealing as best they can with the pandemic and the virtual classroom. So I just beg to differ with what you're saying. Thank you, Mr. Chairman.
All right, thank you, Madam Pro Tem. Let me read into the record Matthew McClure with the Jefferson Parish School Board in opposition, do not wish to speak. Danny Garrett with the Louisiana School Board Association have a card for information purposes. I don't think there's 2 other cards that came in late in support, do not wish to speak. Wes Watts and Ethan Malone. Members, do we have any amendments? All right, members, we do go in at 3. I've sent a message to the president, let him know that we'll be out in 5 minutes. Finance still in? Okay, good. Well, all right. Senator Talbot.
All right, so the First Amendment is basically just going to say the same, if you look on page 2, lines 16 through 26, that same burden of proof or that same high bar to recover attorney fees, we're going to put that in for the kids during the pandemic as well. So that's the First Amendment. Right now, there is none. So I'd like to put that in there. That's what the amendment does.
All right. Is that 667?
Yes, sir.
Okay. Any discussion on the amendment? And Romero, you had a copy of the amendment, right? Yeah. Any objections to the adoption of the amendment? Seeing no objections, that amendment 667 by Senator Talbot is adopted. Do you have another amendment?
Yes, sir. The Second Amendment, so currently the way the bill sits, for a kid who was suspended, just a standalone suspension, he or she would have that right to the hearing, the 30 days of the hearing in front of the school board. This would say just those that were recommended for expulsion or were recommended for expulsion and then reduced down to suspension. So like the superintendent said, they won't be overwhelmed with, a kid that had a 1-day suspension. He wouldn't get a hearing just like in current law. So I think that's a little more kind of splitting the baby.
Okay. All right. Any discussion on Amendment 670? All right. Any objections to the adoption of the amendment? And before we take that vote, and Representative Romero, you have seen this amendment. All right. Any objections to the adoption of the amendment? Hearing no objections, that amendment is adopted. Do we have further amendments to the bill? All right, members, you've heard the testimony on House Bill 83 by Representative Romero. What's your pleasure? Senator Mizell moves that House Bill 83 be reported as amended. Any objections? Hearing no objections, that bill is reported as amended.
Senator Abraham now calls back House Bill number 83 by Representative Romero. It's an act to amend Title 17 relative to student discipline.
Senator Abraham.
Thank you, Mr. President. This bill is, I know, got a lot of attention, but let me just kind of review with you what it does. It provides two things, basically. It provides judicial review of certain student discipline cases. during virtual school. Okay, which way do you go on a judicial review? That's number one. Number two, it asks the governing authorities to develop a protocol for disciplining students participating in virtual instruction. So that's the two criteria that this bill sets out to do. Gives you a judicial review, also asks the governing bodies to propose certain rules. So in the Education Committee, we adopted two amendments. The first one was if you had a expulsion, this applies to expulsions, but it also applies to an expulsion that was reduced to a suspension. Not all suspensions, just expulsions that were reduced to suspensions. This is what it applies to in virtual learning. That was amendment number one in the Senate committee. Amendment number two added, if you had a judicial review, you first go to the school board. If the governing authority doesn't work, then you can go to the courts. If you go to the courts, you can have reasonable attorney fees if the action qualifies for a gross negligent case. Okay, so we set the bar kind of high on how you can recover reasonable attorney fees if you decide that you go to a court action if the school board did not give you the proper instruction that you wanted. So that's basically what this bill does. It pertains to virtual learning only during the COVID situation, the COVID dates. Okay. After that, the school boards will adopt their own set of rules, and you go from there. So we're just honing in on virtual learning during the Laura and Hurricane Delta and in the pandemic situation. Be happy to answer any questions. I see I have some.
Amendments sent up by Senator Connick. They are set number 814. 814.
Senator Connick, on your amendments. You can come on down, present your amendment.
Members, with this amendment, I'm going to read it to you. It concerns if you have a case filed against the school board and the judge determines that this case is brought in bad faith, or it's unreasonable, or it has no merit, it allows the judge to award attorney's fees to the school board. Now, as an attorney, if someone comes to you with a case, in this case, against the school board, if you have the law says this type of language, you're going to really pause and say, okay, is this case valid? Is it has merit going forward? And if it does, this wouldn't concern you. But if it's a shaky case, then you go forward with it, then you risk, if you lose, getting penalties awarded against you. So it reads, if a judgment is rendered in favor of a school board in an action provided for this paragraph, it may include an award for reasonable attorney's fees if the court finds the action was brought in bad faith or otherwise without sufficient merit. It's a pausing effect of whether or not a case should proceed under this law. I have a question.
Okay, Senator Talbot for a question on the amendment.
Thank you, Mr. President. Should we do this for auto wrecks too? Just out of curiosity?
Absolutely not.
Thank you for your consistency.
All right. No, I think it should be for auto wrecks, for any case.
Okay, there are no more questions on the amendment. Hold on, Senator Carter, you have a point of order? Okay. Is there any objection to the adoption of the amendment? Senator Abraham objects. Senator Abraham, state your objection.
I think we already have parts of the law that require reasonable attorney fees for the teacher. I don't know if it's totally needed for the school board itself. That's my position on it.
Okay, Senator Connick has offered up an amendment. Oh, you have a right to close.
Members, this language applies to the school board because the bill only applies to school boards. The language concerning the teachers, that's a different section of law that's not affected. But this is the school board bill. It affects the school board, so the school board can be awarded the fees for if a case is brought against them without any merit. You know, I ask for favorable passage of this amendment. Thank you.
Senator Connick has offered up an amendment to which Senator Abraham has objected. When the machines are open, all those in favor of adoption of the amendment will vote yes. All those opposed will vote no, and the secretary will open the machines. Vote your machine. Senator Tarver, no. Senator Barrow, no. Senator Jackson, is that a no or yes? Senator Jackson, that's a no. Okay. That's a no. You through voting? Senator Boudreau? No. Okay. Close machines. 14 yeas and 21 nays, and the amendment is rejected. No hitchhikers allowed. No more amendments. Okay, so Senator Abraham, you have a right to close on your bill.
Yes, I believe we do have to do something for the virtual learning and put certain protocols for the school board to see what is right and what is wrong during virtual learning. We need some rules there. This is what it does. Provides for reasonable attorney fees under gross negligence. I think it's a good bill. Some people call it the BB gun bill. I'd appreciate your favorable vote on it. Thank you.
Senator Abraham moves final passage of House Bill 83. When the machines are open, all those in favor vote yea. Those opposed vote nay, and the secretary will open the machines. Vote your machines. You through voting? Senator Tarver, yes. Senator Barrow, yes. Close machines. 35 yeas and 0 nays. The bill is finally passed. Senator Abraham moves to reconsider the vote by which the bill passed and lay that motion on the table without objection. So ordered. Senator Fields moves to open the machines for co-authors. If you'd like to co-author when the machines are open, vote your machine. Vote your machine for co-authors. Senator Tarver, yes. Co-authors. Close machines. 25 co-authors.
Representative Romero.
Next bill in this order is House Bill 83 by Representative Romero relative to student discipline, judicial review of certain disciplinary actions. And members, this bill has amendments by the Legislative Bureau as well as Senate Committee Education Committee minutes. Amendments.
Representative Romero on your bill.
Thank you, Mr. Pro Tem, and thank you, members. Members, this is 83. This is the Kamari-Harrison Act, and we concur with the amendments that came over from the Senate side. They did add one amendment that takes out the ability to be able to appeal a suspension, but you still get the appeal for a expulsion to suspension. So we agree with that because you can have a simple 1 day or 2 day suspension that wouldn't need to go to the court system. The other amendment just deals with the reasonable attorney fees, and that's still in there, but it's for gross negligence. It's for a really bad situation. So we concur, or I concur.
There are no questions. Representative Romero moves to concur in the Senate amendments. All those in favor vote yea. All those opposed vote nay. Madam Clerk, you please open the machine. Representative Tavansky, yea. Representative Davis, yea. Representative McGee, yea. Representative Gary Carter, yea. Members, are you through voting? Madam Clerk, close the machine. 92 yeas, 0 nays. 93 yeas, 0 nays, and the amendments are adopted.